I'm Judge Carolyn Tornetta Carluccio, Chair of the Montgomery Bar Association Community Outreach Committee. Our courts are widely regarded as some of the best in the world, but not all of our laws make common sense. That's why we have lawyers and judges. As Americans, we all have rights, and lawyers are here to help protect those rights. In this segment, Joseph Clement and Joseph Bagley of the law firm Wisler Pearlstine will help you understand what you need to know about the right to know law.
What is the right to know law? The right to know law is a new law effective in 2009, adopted in Pennsylvania, which changed the landscape of citizens requesting public records from local agencies in the state. Unlike the prior law, citizens under the new 2009 right to know law simply had to make a request, and the burden shifted to the local government or other agency to either produce the record or prove why under the law the record did not have to be publicly disseminated.
The purpose of the law is to promote the free exchange of information between local governments and the citizens of Pennsylvania. The law also encourages citizens to trust in their local governments. What types of records can you obtain? You can request anything. The burden is on the local agency or the government unit to show that the record is protected by law. Typically, types of records that are requested are ordinances, budgets, meeting minutes, and even emails. Anything that has to do with the agency's business or government's business can be requested and obtained under the right to know law.
Public records include records that are generated by a local government or other agency, records that are received by a government, and records that are in the hands of a government contractor that have to do with the relationship between the government contractor and the public agency.
So how do you make a request under the right to know law? You can make a request in writing or orally. Many times you can walk right into the local government agency and make the request of the open records officer in person. However, there are distinct advantages to making a request in writing.
It's important to know when to make a request in writing because only requests made in writing can be appealed to the Office of Open Records. When a citizen anticipates that there will be some type of a denial by the local agency or they anticipate some type of a dispute with a local agency, a citizen wants to make the request in writing because then they can use that writing and the denial that's forthcoming from the agency for an appeal.
A common practice would be to make the request orally at first and then follow it up with a written request.
A citizen who receives a denial from an agency may want to take an appeal of that agency's denial. An appeal is taken by submitting a form to the State Office of Open Records. That office maintains a website on which a citizen can locate forms, a guide to the right to know law, and the text of the right to know law itself.
The website also includes frequently asked questions and a citizen's guide to making an appeal. An appeal must include the citizen's name, the records requested, the agency's denial of the request, and the request itself. In addition, the requester must provide why they believe that their request should have been allowed, and the records should have been provided to them.
On behalf of the Montgomery Bar Association's Community Outreach Committee, a group of lawyers and community leaders from Montgomery County, I'd like to thank today's presenters. Be sure to check back soon for more information on what you need to know about the laws that impact each one of us.